Emily, with regards to Trump saying the things, though, that's definitely has to be a little bit better news, definitely compared to what continuously we're getting statement from the Trump administration. But with Stephen Miller as the immigration advisor and who is actually taking charge of what's going on, what do you see in the coming in the next 3 years? How Trump administration did he flip 360 degrees over and then saying that now we're going to see good news for the H1B people, or is it going to be the same stance what it was in the past 1 year?
Yeah, I don't think that he's going to change anything in terms of making H-1Bs easier to get or eliminating the $100,000 fee that he put into place. I mean, I chalk this up to when he said that we should put green cards, staple green cards to the diplomas of F1 student visa holders once they graduate with a master's degree. Obviously, that didn't go anywhere. You know, it's nice to see that he realizes that the H-1B does provide a important tool for the American economy. It provides us with the necessary talent when we don't have that talent, when we need training to get that talent. He talked about the battery plant with people from South Korea who were here lawfully doing their jobs to get that plant up and running, training US workers, and ICE came in and detained them all and sent them all back home. And how we really need to actually allow people to come into the US to be able to train US workers in these new and emerging technologies and in manufacturing things that we don't have a history of in our economy. So that was nice to see. But as you mentioned, Stephen Miller is still the person in his ear that's actually pushing forward with policy. And so I don't see any positive coming from those comments. I think he's still moving ahead with the $100,000 fee. I don't think there are any plans to make the H-1B any easier for anyone. And they are likely to increase requests for evidence, increase fraud detection, just based on everything else that they've already been doing since January.
Just because of this statement, if you want to make any travel plans where you think so that U.S. consulate is going to welcome you, give the H1B stamping and H4 stampings, don't believe in that at this point of time, guys. So still take it with a pinch of salt, especially if you're planning to travel. I would cautiously advise you not to. If it is really emergency, then I want you to get an advice from the immigration lawyer to make sure that everything is going okay before you can make a travel plans. In the coming years, as Emily has pointed out, it's going to be a little bit tougher, definitely. It's not going to be easier just because of the statement. Emily, we have seen a lot of fraud, definitely. Yeah, I would say a lot of fraud, but there's definitely a fraud in H1B. I would say about 5% of them we see the people who file in-house projects, the people who file where there is no job and they file from PO boxes at H1B as if that they're working. Hundreds of people are working from PO box. Now, this project firewall seems to be that they're using different kinds of softwares to detect what is fraud, where is fraud. How do you think so this is going to impact? The rumor is that there are 175 companies under the radar at this point of time. Mostly, I'm assuming that these are the consulting companies that filed fraudulent H1Bs, Emily. What do you say?
Yeah, I think that's just the beginning. I think we're going to see way more of that. I mean, if you think about um, a lot of employment-based immigration is online filing. So we have LCAs for H-1Bs that are filed online. We have the H-1B registration, which is filed online. We have PERM filed online. We have prevailing wages filed online. And some employers do use the online filing of the I-129 form, small companies and that sort of thing, although it's not used a lot. But because you have all of these databases gathering information, it makes it much easier for all the different agencies involved to share that information and cross-reference it and see if what's stated on one side is actually happening, on top of the site visit program where they're targeting certain types of companies that they know have a higher rate of fraud. So I think this is just the beginning. We've definitely seen in requests for evidence, notice of intent to deny, notice of intent to revoke, where they will look back at prior H1Bs, look at what the LCA said in that prior H1B, look at the recent pay statements, look at the W-2s and say, hey, 3 years ago, said you were going to pay this person $100,000 a year. We see that you've only been paying $90,000 per year. Therefore, we intend to deny because we think you're not in alignment with the H-1B program LCA regulations. And rightly so, they should be doing that if that's the case. It is good that they are looking at these companies and rooting out that fraud. So the legitimate companies, the legitimate employees, one would hope would have an easier time. I think the hard thing is when you have these government databases and they're using AI and using these programs, it tends to cast a very wide net that makes legitimate companies jump through more hoops than what are necessary, slows everything down. You have more RFEs, everything takes longer. So that's the downside of it from what I expect to see. And I do think there's going to be more coming.
Emily, we have advised people that for the people who are on H1B, who loses a job, we have advised they can move to change the status to B2. We definitely promoted that. We definitely also give advice with regards to the compelling circumstances EAD. We also told that you can always go back to your home country and come back into United States. We also told if there is H4 option, please move to H4 now. Also, if you move to F1 if you need it to. Now, with the $100,000 fees, what are the changes that you will advise the people? What previously you advised something, do you intend to change any of your advices right now?
Yeah, I think the big one that you mentioned is the compelling circumstances EAD is very unattractive when you have this $100,000 fee. Because once you get onto the compelling circumstances EAD, you are no longer in a non-immigrant status, which means that once you do get a valid H-1B job offer and you're ready to move back to H-1B status, you can't just file a change of status from compelling circumstances EAD to H-1B. That only works if you're in a non-immigrant status, like a B2 or an F1. So for compelling circumstances EAD to get back to H-1B, they have to leave the country, which means the company is going to be filing a consular processing H-1B request, which means the $100,000 fee is going to be triggered. So once you get on that compelling circumstances EAD, there's really no coming back until the $100,000 fee goes away. I do still think probably the B2, unless of course you have an H4 option or something like that, but the B2 is still a good option and probably is the best option because once you get on B2, when you do have that new job offer, and you need to get back to H-1B, you can file it as a change of status while you stay in the US, which means that the $100,000 fee does not apply when you're getting back to H-1B. So we are still routinely filing change of status to B2 for people who are in that situation. We're currently filing change of status back to H-1B for a lot of people who had to file B2s during the government shutdown because they couldn't get their transfer filed in time, and those are being processed normally. So I still think that's a good option.
Yeah, and people are always asking questions. They do come to the daily Zoom calls and ask questions. Hey, can I move back from B2 to H1B without going through the consular processing? Absolutely, you don't have to go through the consular processing. You can change the status within United States, and you're not subject to $100,000 fees. Of course, the same thing is applicable for H4. If somebody has an H4 or a B2, definitely I would prefer a H4 option would be much better. Emily, right now, students are traveling. This is a Christmas time. They want to travel. What do you speak about people who are on OPT and STEM extension and they want to travel outside the country and coming back? What are the precautions that they need to be worried about? You have consistently said that on the OPT, they're allowed to do an internship, unpaid internship. However, we have seen some of them getting deported in Chicago airport and also in Abu Dhabi airport. They were not turned back into because they worked as a unpaid internship in the OPT period. So if somebody worked without pay in the OPT period, should they be concerned about it?
I think they should. Although, if the unpaid internship does meet all of the Labor Department requirements to qualify as an unpaid internship, it does count as an employment for the initial 1 year of OPT time. There are a lot of people who did unpaid internships that maybe don't meet those qualifications, and those CBP officers are assuming that if you're doing an unpaid internship, that is basically being unemployed. And so they're thinking that you've exceeded the 150-day unemployment limit or the 90-day unemployment limit during your OPT time, and therefore you are out of F1 status, no longer authorized to come back into the US. So it is very risky for someone who has that unpaid time in their OPT history to travel if it has exceeded those unemployment limits.
Let's go to
Um,
questions, Emily, unless you have
sure.
something.
Oh, we can go ahead to
Um,
questions.
Sul from YouTube is asking the question. He has spent 8 months in India, but he was actually remotely working in India at that point of time when he visited India. Does it count towards the 6 years of the H1B, or he can take that off from the 6 years of H1B? He has worked, he got paid. The answer to the question is he doesn't need this 8 months will not be counted toward the H1B period. It will be counted as it will be excluded from the eight in the 6 years though. If you're working in India, you're actually technically, it's you're an Indian national. You can work in India, not a problem. So you can take that. It will not, that 8 months will not be counted towards the 6 years.
Ricky says, if the H-1B wage increase rule comes into play, will it impact existing H-1B workers at the time of their renewal next year? Will the new wages have to be forced on that LCA? Yes. So when they issue the final regulation that changes how they calculate the prevailing wages, the government will go through all of the prevailing wages that they've already calculated, and most likely beginning on July 1st with the next year's wage calculations, they will implement those new calculations, and every single LCA filed after that date will be subject to the new prevailing wages, assuming you're using the OFLC online wage library to get your prevailing wage. There are other wage options like private wage surveys. But yeah, so it will impact existing H-1B workers when they're filing their next extension, or when they're filing a transfer, when they're filing an amendment, anything that requires a new LCA after most likely July 1st, 2026 is going to need to use that new prevailing wage.
Rick is asking the question that he's first time going for the H1B stamping. He got the H1B approval in 2023. What precautions he should take? Well, instead of precautions, I would say that you need to have a plan B. If you don't get the stamping, what's going to happen with your car, your house, your family here? That you need to look into it. The other thing is that if you don't get a H1B stamping, you can always come back in a company B. Right now, the company B option won't be there, because if any other H1B is being filed while you're outside the country, the $100,000 will be applicable. Definitely, I would recommend strongly not to leave unless it's a real urgent. And if it's a real urgent, make sure that the pay stubs are there. You have all the W-2 forms. The LCA is complying with the location where the LCA, wherever the LCA location is, you're working at that particular location. And if you are working for an end client through a consulting company, get a end client letter available for you when you go for stamping. These are the things that you need to take care of. Take the income tax returns and bank statement to support your pay stubs.
BG says, I was laid off on H1 and now on a pending B2. Do you suggest a change of status or consular processing? And should I include a B2 withdrawal letter while filing for my premium H1 transfer? Definitely not consular processing, because that is going to cause the $100,000 filing fee to be triggered. So you definitely need to file it as a change of status from pending B2 back to H1B, and you should not include a withdrawal letter for that B2. What if you ask your B2 to be withdrawn and your H1B gets denied? Now you have nothing. That is a huge risk. Do not do that. You don't need to withdraw the B2 until after your H-1B gets approved. So be very careful with that.
Second. Shriva has this question that if the adjustment of status has been denied and I want to move from AOS EAD to H1B, is the $100,000 applicable? From AOS EAD to H1B, you have to go through the consular processing. If you go to the consular processing, the $100,000 fees is applicable. So you need to, that $100,000 will be applicable if you get the GC denied, you want to move back to H1B.
Bubakar says, what is the travel risk for H-1B holders with a valid visa stamp expiring in 2027? No change in role, job, or employer. It is less of a risk. There's still risk. Number one, I would say, what is your employer's record, immigration history? Is it a strong company? What kind of company is it? What is your role? Are you directly working in-house for a company? Are you working third-party placement through a staffing company? There are certain H-1B filings that have more risk than others. So that's number one. And so assuming everything's great, you're working for a household name company, everybody knows that company, you're like the top person in that role, and it's very clear that you're meeting all of the requirements. The biggest risk for people that have the valid visa is the random Trump uncertainty. I mean, you saw the chaos that ensued when Trump got ready to announce the $100,000 proclamation. Nobody knew who it applied to. Everybody who was outside the country when that happened immediately started trying to make plans to come back before the Sunday midnight deadline, because he made it sound like everybody was going to be having to pay this $100,000 fee or they'll be stuck outside the country. Turns out that's not the case. However, it was very scary for those people who were outside the country. So you don't want to get stuck outside the country when there's any new travel ban that comes up or any new kind of proclamation like that. That's the big risk. And those are things that the Trump administration routinely did during the previous administration. And it's clear that they do that again under the current administration, just with this $100,000 fee as an example.
A question from Jugal is asking very interesting question. This question is coming from a couple of other people also, Emily, and I want you also, your input also, is that do we need to carry the original H1B approval? Do we need to carry the green card approval, a green card with us wherever we travel, especially with ICE, ICE is on the streets? My advice, Emily, please correct me if I'm wrong, is that no, you don't have to, as long as you have a copy of it, though. We haven't had any reports where they have asked the IDs or they have picked up the legal people and put it in the detention at this point of time when they've been going on the streets. We haven't seen those kind of things happening, though. Now, they do have the ICE has a facility where if you provide your copy of your H1B or copy of your green card, though, they can verify that whether that information is correct or not. They're checking the eye scanning thing where they can detect whether you are the right person or not. So I don't see that you need to carry the H1B or the non-immigrant status original or the green card approval. What do you say, Emily?
Yeah, I agree with you. I've not heard any reports of people who are green card holders or H-1B holders who didn't have their document on them and they were detained because of it. And I don't think I've seen anyone have to have an original to prove what their status is, but I would definitely keep a copy of it, take a picture of it, have that on your phone and have it handy, because as you mentioned, they are able to use biometrics and verify identity with all the technology that they have right now. Mahir says, I'm currently on B2 pending and received a job offer. My new employer is supportive and they're going to try their best to get the H-1B transfer done. Are there any likely complications involved? Well, just in any H-1B, you've got to make sure that the job that they're offering qualifies as a specialty occupation. They have the LCA, they choose the proper SOC code, they choose the proper wage level, that you have the education needed for that job, you have an education evaluation if you didn't have your degree from the US. So those are just the basics. Now, when I'm filing a change of status from pending B2 because it's not yet approved, I will go back to the day that the B2 was filed and provide supporting evidence to show that you are properly maintaining status up to the time of the B2 filing and that you've maintained your status since the B2 filing up till the time of the H1B filing. And with that, I don't think I've ever had any requests for evidence on those H1Bs regarding the status. The few times I've seen a request for evidence on those cases, they have very rarely said they want to see the B2 approval before they'll approve the H1B, but once we reply back with all of the documentation showing proper maintenance of status going back to the loss of the previous H1B all the way up to the filing of the new H1B, we've been successful to get those approved.
Step Climax has this question. My wife, who's in H1B, got her H1B approved before September 21st of 2025. That's before the $100,000 proclamation. But that was a council processing. Is the $100,000 applicable? Since the H1B has been filed before the proclamation, the $100,000 is not applicable. She can go for stamping outside the country, not a problem. That $100,000 is not applicable. But actually, she has an option. I mean, if she's in United States, though, since you're an L1, either she has some other non-immigrant visa or she can even come on L2 visa. She can change the status in United States, even though she has H1B approval. She doesn't have to go for stamping. The company can file a change of status within United States. Either they file the change of status within United States or she goes to the consulate. Either way, the $100,000 is not applicable because the H1B was filed before the proclamation.
Tech with Jag says, do you suggest to file a concurrent self-sponsored H1B under the current administration, or will it trigger a site visit, which might not be worth it under this administration? I'm filing them. I'm getting approvals of them. The ones I have filed, as far as I know, no one's had a site visit happen. I do let them know that if they are running this business out of their home and they use that as the company address and the work location address, a site visit can happen at their home. So if they want to avoid that, maybe they could consider getting an office space and using that as the company address. Up until this point, just from my personal experience, I've not really had people have difficulties with site visits for those self-employment or the entrepreneur type H1Bs. I think part of that is the fact that they limit the approvals to only 18 months. So when it's time to file that next extension, we'll probably start to see more scrutiny and them wanting to verify that you've been doing what you said you were going to be doing and that the job is legitimate and the business is operating and running.
Emily, do they need to be fearful if they are doing a genuine self-employment and everything is fine? I don't think so. This administration is anti-new entrepreneurs.
Yeah, I agree with you. I think what I recommend people who are in the entrepreneur H1B is don't file H1Bs for your company. Don't employ other H1B holders, because once you start signing paperwork for someone else's H1B, that is what gets people into problems with their own cases in the future. And I definitely have seen that.
But if the company is filing only for the entrepreneur, you don't see that as a discouragement from this current administration. Is that right, Emily?
No, I don't think they're being targeted in any way for site visits or any increased enforcement at this time.
Not that I'm a fan of Trump administration, but in a way that they actually are promoting the entrepreneurship H1Bs at this point of time. So we don't see that administration is trying to make it hard for entrepreneurs to establish companies and progress in the companies.
Sandeep says, I have an approved I-140 and I'm currently working on H1B. If I convert myself to H4 and stay in the US on H4, can I change back to H1B in the future, even if my H1B has been expired? Yes, you can. Once you have that I-140 approved, the 6-year limit on H1B no longer applies. So you can convert back to H1B at any time without going through the lottery again. You're not subject to the cap. The most important thing to be aware of is that once your priority date of that I-140 has been current for 1 full year under the final action date, then you're cut off. You can't at that point change back to H1B. So you need to monitor the priority date of that I-140. As long as it's not current, yes, you can change back to H1B anytime in the future.
can the debt collection affect the adjustment of status application? Sometimes we haven't seen it at all that it's going to affect the adjustment of status, especially for the employment based. However, there may be some new regulations that may pop up soon, and they may define more if somebody is not having enough financial support to stay in United States. We're also expecting something with related to the health ground to see if they would become if they are a potential burden in United States. So definitely there are some things that are coming up, but as of now, we haven't seen any problem. If there is some collection that is still pending and you file the 485 application.
Praveen says I filed my citizenship on October 20th. Any changes in the applications or otherwise, like this good neighbor certificate for these new applications? Any travel concerns I should be careful of? So the only change that they've implemented is expanding the list of questions that they can ask and the number of questions for the, your knowledge of U.S. history and government and those sorts of things. I don't think I've ever had a employment-based client fail that test. I mean, if you've studied for a master's degree and passed your finals there, I'm pretty sure you can pass the citizenship exam even with these extra questions on it. I have not seen any implementation of this good neighbor certificate where they're, asking around your friends and neighbors to see if you're a good person or not. And as far as travel, just make sure that you are not taking long trips that are going to impact your continuous presence and continuous residence in the country to qualify for citizenship.
Emily, I want your discussion on the Sumit Singh question. Can a H1B holder serve as a board of director for a non-government organization? I'm assuming that it's a non-profit organization, Emily. And if it's a non-profit organization, if he's serving as a board of director, and if it's truly voluntary basis, not expecting any future money from that particular organization, do you see any problem with that?
I think if this is along the lines of kind of a charitable volunteering situation, I don't see any problem with that. It's just like volunteering for the Red Cross to hand out water during a hurricane or something like that. I don't think that's considered unauthorized employment. So I'm not seeing a problem with that. But I think that's different than serving on the board of directors of a for-profit company where you're actually advising the company and much more involved. I don't know your thoughts on that.
Yeah, I agree with you, Emily. If you are a member of any temple or any church or any masjid, these are religious organizations. People don't expect to get paid in those organizations. They don't expect any monetary benefit from those. And if you're serving in some like language, for example, Telugu cultural organizations, Hindi cultural organizations, Maharashtrian cultural organizations, I don't see that any problem. Never have seen any USCIS giving any problem if you're serving in some of those things. We've never, and some of them are like running association, tree planting associations, yoga associations. I don't see any problem in that.
Joe says, my son had aged out after the green card. If I sponsor him on the family-based visa, can I retain his priority date from when he was on H4? Unfortunately, no. So assuming that you were sponsored under the employment-based category and you received your green card, but your son didn't because he aged out, when you file the I-130 under the family-based category for your son, for a son of a green card holder, the family-based category is completely separate. It's a brand new priority date. You basically start at the back of the line for that process.
One second. Questions are asked with regarding to AOS EAD, whether the person can move from AOS EAD to H1B is $100,000 applicable. Here's the rule though, whenever it's a consular processing, guys, it is $100,000. Since adjustment of status is not a non-immigrant status, you can't move from adjustment of status to H1B. So since you're moving to a adjustment of status to H1B, you will have to go to the consular processing. Since you have to go to the consular processing, you will be subject to the $100,000